Good morning, everyone. Firstly, I would like to recognize the Honorable Rayburn Blackmore, Minister of National Security and Legal Affairs, the Director of Public Prosecution, Ms. Shema Dirampel, Senior State Attorney from the Chambers of the Attorney General, Mrs. Vanica Sobers Joseph, Acting Chief of Police, Mr. Davidson Valerie, members of the media, and listeners and viewers tuning in. I would first like to call on the Acting Chief of Police to do a prayer for us before we start with this press conference. Thank you.
Let us pray. Almighty God and eternal Father, we thank you for today. We thank you for your goodness and we thank you for your mercies. We thank you, Lord, for the gathering this morning, this press conference, as we discuss, Lord, the matters of the state and national security. I thank you, Lord, for the Ministry of National Security, and for all those, Lord, who help make and shape things legally in this country. Father, Lord, we welcome your presence among us. We ask that you bless the proceedings here this morning, and that, Lord, you bless every person who will contribute and will deliver in discussion on this session today. Thank you for this opportunity. Thank you for your grace, and thank you for your mercies. For we ask in Jesus' name, amen.
Okay, so good morning once again, and I would like to thank you, the media, for accepting our invitation to this press conference, which was called to give the public additional information on the recent court ruling on the constitutional claim as it relates to Section 14 and 16 of the Sexual Offences Act. Today, we will first hear from the Honorable Minister, followed by the Senior State Attorney, and then lastly the Director of Public Prosecution. After which we will take questions from the media. Without any further delay, I would like to call on the Honorable Rayburn Blackmore, Minister for National Security and Legal Affairs, to give a submission.
Thank you very much, Acting Deputy Registrar General. Good morning to everyone. Let me first recognize in our presence the Acting Chief of Police and also the Senior Administrative Officer in the Ministry of National Security and Legal Affairs. And I also want to recognize the Director of Public Prosecutions, and Ms. Shema Dirampel and Mrs. Sobers, the Senior State Attorney in the Office of the Attorney General. And how can I not thank you for being here this morning, members of the media fraternity, those of you listening and viewing in Dominica and overseas. Good morning. Good morning. Let me firstly begin by as I said just now, by thanking each one of you for being here this morning on a press conference which I believe is very timely in the circumstances, and to further inform the public and yourselves on the recent court ruling. Let me just emphasize clearly here this morning that the purpose of this press conference here today, one, is not to castigate or black eye any individual or any group of our society, but more or less to address and to dispel frontally the misconceptions and superimpose views that do not represent the recent court ruling on burglary and gross indecency, namely Section 16 and 14 of the Sexual Offences Act 1046 of the laws of Dominica. I want to also take this opportunity, as we did last week Thursday on a special program on the nation's station, DBS Radio, to highly commend the Attorney General and his staff, the Solicitor General, who is currently on maternity leave, Mrs. Sobers, the acting senior state attorney, was intimately involved in representing the state. And let me just say that this is a matter from day one that your government took very seriously, and consequently retained some of the best minds in those matters, namely Dr. Dossett, David Dossett of Antigua, and there were other interested parties. The church fraternity, who also responded to the claimant's challenge, reference the Constitution. As you know, Section 16 and 14 will challenge on the basis that they infringe on guaranteed rights of a particular group of people within our society. I want to also say, in clear and simple terms, let me emphasize, in clear and simple terms, that burglary is still a very serious offense within our statute of the country. The notion that burglary is no longer an offense is false and fundamentally misplaced. What the court did in its recent ruling, as per the challenges brought against the Attorney General representing the state, was to simply qualify the law insofar as Section 14, which deals with gross indecency, and Section 16, which deals with rape. When I say qualify, what do I mean? Reference to the challenges brought, and there were many challenges brought, and just now we're going to hear from the Senior State Counsel, who will give further context to the ruling and the challenges that were brought against the state. And in those, many of those challenges, the court agreed with the state. I should reference that insofar as it relates to one's rights to freedom of association, or freedom of expression, one's rights to security, and the whole notion of one's right being violated on the basis of sex. Our Constitution does not reference sexual orientation, so there's no justification in the circumstances to have brought such a challenge against the state and to have succeeded. But Mrs. Sobers will give further context to that. So, what is the ruling in a nutshell? is that two adults within the confines of their privacy, two consenting adults within the confines of the home or privacy, the police cannot bring charges against them. They are within the confines of the homes and they have consented. The misconception that burglary only speaks to an act in that form, I don't like using the word, between man and man alone is false. Or Sexual Offences Act, which is one of the most comprehensive in the Caribbean, also before that ruling penalized two adults engaging in that kind of activity, even if they were within the private space and they consented. It also criminalized that act between male and female. Now, what is the law? So, burglary still stands insofar as it refers to one, minors. So I used to say, a minor is defined according to our laws below the age of 60. And as per our laws, a minor cannot give consent. So even if the minor were to say yes, that is not consent as per our laws. And then the penalty for that is 25 years imprisonment. That still remains on the book. If you're an adult, and even if you are within your private space, and you do not consent to that such activity, anybody violating you, be it a male or a female adult, without your consent, that is burglary, and you'll be charged by the police for that. At absolutely no time is burglary or gross indecency permissible within the public domain. Even if you were to consent, you are two consenting adults, you cannot be involved in that activity at the public washroom, in the bamboo house in the gardens, anywhere within the public space. That person or the two people will be arrested. I want to set the record straight on that. Let me just say further that this is not a lifestyle I subscribe to, neither I will ever subscribe to. But the parent law of the country is the Constitution. And if we were to make a reference to some of the sentences and quotes within the forewords of our Constitution, which says that the Constitution of the Commonwealth of Dominica is founded on the principle that acknowledges the supremacy of God. It goes on to reference the position of the family within a society of free men and free institutions. It goes on to say and speaks to the guaranteed rights of citizens within the Constitution, which means, therefore, any member within the society who feel aggrieved and who believe that any law enacted in Parliament is not intra-virus, that person has a right within a democratic society to challenge that law. And let me say also that there were similar rulings in countries with similar social and cultural realities and similar laws. If I were to reference St. Kitts and Nevis, Antigua, Trinidad, Barbados, and Belize. That notwithstanding, and we have to also understand that over the years, since our independence, our jurisprudence as a country and as a region has emerged. Laws will be challenged, courts will give rulings on those challenges, and that will constitute precedent. And once precedent is established, you're obligated to follow the ruling of the court until that ruling is challenged or it falls. And even if we do not subscribe to a particular lifestyle, but within a democratic space, we have to abide and comply with the rule of law. The notion that it is the government and poor honorable Rivers Kerry who legalize burglary or gross indecency is malicious, is wicked, and fundamentally misplaced. We also have to have an appreciation for the separation of powers. What we did, I was a minister then and I'm still a minister. In 2011, we met with all the relevant stakeholders, spearheaded by Mr. Ray Harris, a distinguished draft person in the Caribbean and the world by extension. And we examined critically the 1998 Sexual Offences Act, and we significantly almost rewrote the entire act, and expanded the scope of a number of offenses that were not previously in the 1998 statute. That is what we did. Before that, our law did not speak to issues like grooming, which of course protected our minors. What do I mean by grooming? Some of us like to use cell phones and to send messages. So if you were to use your cell phone, and we like WhatsApp, and communicate anything that can be inferred to as a sexual inducement to a minor, that is grooming, and you can go to jail. One of the elements I want to stress before I call on Mr. Sobers is that when we passed the Sexual Offences Act, Dominic was heralded by the Commonwealth Secretariat and a number of international organizations, to the extent to which a delegation including the Speaker of the House and myself, were invited to this Commonwealth Secretariat to share our experiences with the rest of the global space as to how advanced we were when we criminalized the whole issue of husband or wives. Before that law, a wife could not have said no to her husband. It was okay to have forced your wife to have sex, whether she was sick or not sick. We criminalize that. This isn't a law. It was not there before. Likewise, a wife cannot force her husband to have sex. That is criminalized. That is how far-reaching. We went to Parliament in 2011 and to enact basically almost a new Sexual Offences Act, because we are minded by the fact that our society, our parent law, speaks to the supremacy of God. And that is why the Sexual Offences Act and a number of pieces of legislation within the criminal statute are drafted in a way that seek to preserve the issue of morality on our Christian belief. But the world is evolving, the world is changing, and people will challenge a number of pieces of legislation. So I call on the public and those of you who have a very important role to play by disseminating information to the public, have a moral responsibility to ensure that you're not reporting stories or Beth, but you're in fact reporting the news. And news is not about you. It's about the event that you are reporting to the public. So you play a very important role in that regard. I will now, we'll have questions and answers after the various presentations. So you have all the time to get everything clarified here this morning. And I just want to take this time off again to say thank you for coming and thank you to all listening public thus far. Thank you. So as I go again, let me just say that burglary is still an offense, a serious offense. I want this DPP speak to make reference to the penalties that still exist within our Sexual Offences Act. Very serious offense. Sentences. For a matter of fact, let me just say that the court does not have any discretion when it comes to issues of burglary. It's custodial sentences. You must go to jail once you're found guilty. And just recently, somebody was sent to jail for violating a minor to 18 years imprisonment. That's how serious the laws are on the books, and that is what our focus ought to be. So the rulings speak to people who are protected under the Act. And let me just say as I end, a minor, an adult who does not consent. So even if you're above 18 or above 16, and even if you're in a private space, in a hotel room or at home, and somebody has forced you to do that, whether the person induced you, use alcohol or drugs or whatever the case may be, or the person overpower you physically and violates you, you can call the police and the person will be arrested and charged for burglary. And I'm not sure how simple it can get. So our concern ought to be the vulnerable in our mix, and people have a right to say no. And it applies also, let me just say, male and male and male and female. So it's a gender neutral piece of legislation. So if a woman says no to a man, even if she's an adult, even if she's within a private space, and that man were to have that kind of intercourse in that part of her body, but is recognized by the law as burglary, and she makes a report to the police, he will be arrested and charged for burglary. Thank you very much.
Thank you, Mr. Honorable Rayburn Blackmore, for your presentation. We will now like to call on the Senior State Attorney of the Chambers of the Attorney General, Mrs. Vanica Sobers Joseph.
Thank you to the Acting Deputy Registrar, Ms. Gayantuse. Good day to everyone. I wish to acknowledge, of course, the presence of the Honorable Minister of National Security and Legal Affairs, Mr. Rayburn Blackmore, the Honorable Director of Public Prosecutions, Ms. Shoma Darampo, the Acting Chief of Police, Mr. Davidson Valerie, members of the media present here, members of the public listening via online or radio. I would first like to say that in this case, I wish citizens to understand that there is a separation of power. I think in social studies, way back when I learned it, we learned that there is the executive branch of government, there is the judiciary, and then there is the legislature. Legislature being parliament, judiciary being the court, executive branch of government being the government as we know it. And so parliament would make laws, and then these laws are interpreted by the courts. In this instance, as the Honourable Minister has indicated, Parliament passed a very robust Sexual Offences Act, and that act recently was subject to a constitutional challenge. It is known, and I wish to reiterate, that the Constitution of Dominica is what we call the supreme law of the land, much as is the case for Christian persons who believe in God. Your God is your supreme authority. Now, in Dominica, the law, and in other places, is organic. The law does change as time and societies change, right? And citizens, by virtue of the Constitution, do have a right to challenge those laws. And that is what happened with this case, and that is what will and may continue to happen with any case where a citizen feels, whether it is with respect to the activities under the Sexual Offences Act, as was happened in this case, or your freedom to associate by virtue of a trade union or otherwise. You are empowered by the Constitution to challenge any law that you feel infringes on your rights. And in this case, a citizen did so, and the judgment was given, and the judgment is basically what we are here to discuss and to explain in as simple terms as possible so that the media can educate persons, and that you as a member of the general public in Dominica and extension overseas, and as a citizen of the Commonwealth of Dominica, know what are the confines of your rights within the confines of the law. Okay? That being said, I know that there may be certain persons who are of the opinion that the way the state presented their case, we did not defend the case, and I would like to say that that is not a current or correct characterization of what happened with a constitutional claim. When it is filed with affidavit in support, you would find often an affidavit in reply. And if a document in this case is seen and there is no defense written anywhere on it, I would like to clarify that an affidavit in reply, known as a defense in constitutional claims, was filed on behalf of the state. And at the time that the affidavit was filed, the state presented, and that was quoted in the court judgment, that the premise that the fact of the law being as it was then, that the law being as it was then was subject to being discriminatory to certain members of the public or put certain members of the public in fear of how they could live their life was untrue. The police does not enter into private citizens' homes and try to regulate their personal conduct within the confines of their home. The Constitution protects that. Whatever you do within the confines of your home, the Constitution will protect you in as much as a complaint, a criminal complaint, is not made against you. And as the minister said, for this case, if there are two adults consenting in private, the law never has, and as with this case, will not in the future seek to arrest and charge anybody for acts done by two consenting adults. And let me restate, adults, male to male, male to female, female to female. Okay? And I would like to say that as clearly as possible. Now, the minister did a very good job in explaining that in Dominica, we have what we call a common law system of law, which follows precedent. On what is precedent? Precedent is that an earlier case is regarded as an example or guide to follow unless the case is substantially different in facts and in law from the case that is before you. In this particular case, the BG versus AG case, there were at least at the time of hearing 3 similarly decided cases, and subsequent to the hearing, and hearing I mean the day that we went to court to give arguments on the matter. And as of now, there are 4 cases. There is the case from Trinidad, there is a case from Belize, there is a case from Antigua, and there is also a case from St. Kitts and Nevis. Now, with those cases, they were all constitutional challenges as well. And the challenge was whether or not Section 14 and 16 of the Sexual Offences Act contravened the rights of the individuals. And the different cases had different prongs of arguments. But for the purposes of our case, their arguments ranged from the section prohibited the freedom of association, it discriminated based on gender or sex, sex, and that the right to privacy by virtue of the section just being on the books were infringed. And for our case, the state set out that Section 14 and 16 did not contravene the protection to personal liberty. It is not in contravention against the protection against inhumane treatment. It is not in contravention against the provision to secure protection of the law. That was how the state presented its case. We also indicated that not every complaint that is covered under Section 14 and 16 contravenes the Constitution, and there is value in protecting persons who do not consent and protecting minors. And minors, for the purposes of Dominica, are persons under the age of 16. The offense of buggery, as the minister has indicated, still remains on the books. The case has only qualified who it applies to and who can be criminally charged. And I would like to restate that decriminalization is not legalization. Decriminalization simply means that you will not face a criminal charge for the offense. And who in this context will not face a criminal charge for the offense? Two consenting adults in private. When one adult in private does not consent, and the adult that does not consent, decides to make a report to the police under the law is empowered to investigate it. Where a minor is subject to the act, a minor in law cannot consent, and a complaint is made to the police will investigate it and is empowered under the law to investigate it. In our circumstances, it was practical and in the interest of administration of justice as officers of the court to be aware of the precedents and to note the precedents, and despite whatever personal views we may have on the matter, to follow the precedents. I would like to restate that Dominica is a moral society, it is a religious society. The legislation, the case does not prevent you from exercising your choices as a Christian or whatever denomination that you subscribe to. At the end of the day, these are personal choices, and the Constitution protects persons' rights to exercise their personal choices. It is important that we are respectful as citizens of other persons, whether we agree or we disagree with how they choose to exercise their choices. That being said, I would like to emphasize that in this case, the court did agree with the Chamber's position that the law did not infringe anyone's rights as it relates to their security of person. It did not infringe, and the state, the police, does not infringe the rights of persons as it relates to discrimination based on sex, the law as it stood then and the law as it stands now. And the law does not infringe the right for freedom of association. I say all that to say the claimants presented the case that they wanted a declaration that the law prevented them from freely associating, that the law discriminated against them based on their sex, and that the law prevented them from having a right to security of person. And the court ruled and decided that that is not a correct interpretation of the law. The court, however, did make the concession that the Constitution guarantees persons the opportunity to exercise their rights in private once there is consent. Now, I wish to end by saying it is important to remember that this is not a claim about moral rights. This is not a claim about personal choices. This is a claim about the Constitution and what rights the Constitution can properly protect in a society as it changes. Thank you.
Thank you, Mrs. Sober Joseph, for your presentation. We will now call on the Director of Public Prosecution, Ms. Sherma Dairampu.
Good afternoon, all. I wish to adopt the protocol established by the learned Acting Solicitor General. The role of the Office of the Director of Public Prosecutions in this realm of things right now is to prosecute matters pursuant to the Sexual Offences Act. But the first question I asked after I heard the judgment, has this judgment changed the social context of Dominican society? Yes, concessions, as the learned Solicitor General indicated, so concessions were made, certain rulings were made by the court in respect of the legislation. But has the social context changed? Has the way things been operating changed so drastically? When I saw the headlines, burglary laws banned, was that really what the case said? Now, the social context was that for us to prosecute sexual matters, for example, burglary, you must have a victim. So if we had matters where they were consenting adults, they would never be brought to the court. Actually, in the case, it is acknowledged at paragraph 9 that there were no burglary matters before the court in which consenting adults were involved. I have been at the Office of the Director of Public Prosecutions from since 2012, and I've never seen a matter of burglary where it involves consenting adults. These matters, burglary matters, are usually brought in the context of where it's a minor who cannot give consent, or where an individual does not consent to that act. So really, yes, the court has made certain rulings so that the law can be kept within the confines of the Constitution. But at this stage, I would say that the social context itself in Dominica has not been changed by the rulings. So don't be scared. Don't think that you know what the moral standards that you hold are no longer existing because of that particular case. Now I'm going to take you through the particular sections. Burglary is pursuant to Section 16 of the Sexual Offences Act. And this was one of the sections that came up for discussion in the case. Section 16 defines burglary as sexual intercourse per annum. And what has happened now is that the court is basically saying that where burglary is committed between two consenting adults, that is a man and a woman and a male, that within the privacy of their homes, there's nothing illegal about that, which really what was happening in Dominica. We were not prosecuting these matters. We have never prosecuted matters of that nature. Prior to the ruling, burglary between consenting adults, be it male and female, male and male, was illegal. Right now it's decriminalized to the extent that between consenting adults, we cannot prosecute these matters. Now we still have burglary on the books. The act of burglary in respect of a non-consenting adult and also in respect of minors. Now, members of the public have met me and they've been asking what happens to the recent convictions that have been obtained, because as of recent, the Office of the Director of Public Prosecutions prosecuted over the past 2 years 2 burglary matters. one of which involved a minor, the other was a non-consenting adult. And so is this case going to be squashed? Is this ruling going to be overturned in keeping with the case? No. Solely because what the way in which the law has changed is in respect of consenting adults. So matters we've had before in respect of minors, where adults were brought before the courts for committing the offense of burglary against a minor, or someone was brought before the court for committing the act of burglary against an adult who has not consented. These matters are safe convictions because it's in keeping with the recommendations made in the case, the constitutional case. Now, burglary, a lot of people may want to know, what is the penalty for burglary? Burglary against a minor is 25 years imprisonment, custodial. The minister indicated that the court does not have a discretion when it comes to that. The Sexual Offences Act is one of the most robust, if not the most stringent sexual offences act in the Commonwealth of the Commonwealth Caribbean is Dominica's Sexual Offences Act. It was amended in 2016. And for burglary, you can get a sentence of as high as 25 years imprisonment when it is committed against a minor. When it is committed against a non-consenting adult, you can get up to 12 years imprisonment. So the sentences are very strict and the sentences still remain. The only minor concession, I would say, is that consenting adults in the privacy of their home, they can engage in the act. That's not our business. But where it comes to an act being committed against a minor, these matters will be investigated by the police, will be prosecuted. Where it's a non-consenting adult, they will be investigated by the police. Now, we also have the act of gross indecency, which is governed by Section 14 of the Sexual Offences Act. One may wonder, what is gross indecency? And gross indecency is basically someone performing an act, whether natural or unnatural, by a person involving the use of the genital organs, breasts, or anus for the purpose of arousing or gratifying sexual desire. This, too, has very stiff penalties, but the case only indicated that in respect of gross indecency, where you have individuals doing it in the privacy of their home and they're consenting individuals, it's okay. And again, as I said, we have to consider the social context. Have the police been rushing into people's homes to see what they're doing in the privacy of their homes or if they're in their private settings? No. These matters were only being brought to court when they were being done in public. When a minor was being violated, when a non-consenting adult in public was being violated. Now, the act of gross indecency, where the complainant is a person 16 years of age or more, the sentence is 12 years. And where the individual is a minor, where you have a victim who is a child under the age of 16, the sentence is 20 years. So these offenses carry very severe penalties, and the case, this decided case, has not changed anything in respect of the penalties for these offenses. They remain as is. Even so, for the act of gross indecency, it has been qualified to the extent that the individuals have to do it in their privacy, their private settings, their home. It does not, if it happens in a public setting, matters will be prosecuted. So when individuals say that, the case said that gross indecency is legal now, when I go to a public area, can two males engage in their act? No. this cannot be done because it's not within a private setting. And at the end of the day, we can never prosecute something that is done within a private setting, a sexual act done within a private setting, unless there is a victim. Someone is saying, I did not consent, or the person is a minor. The individual is a minor who does not have the right to consent. If an act is being done in a public area, an act of gross indecency, an act which covers the elements of gross indecency, the police have every right to investigate and prosecute. So it's not the case where all decency in the Commonwealth of Dominica has gone down the drain, as some of the headlines may try to indicate or bring forth. It is a matter where the court is saying internationally, because cases on the international plane will also refer to cases coming from the US, from Botswana, that the society is moving to that particular, being liberal in respect of that and understanding the law that certain people have rights. There's a group of people that have rights, they consider to have rights, but these rights, their freedom of expression, cannot be forced on members of the public that do not, or the members of society that do not subscribe to that concept. And it's not something to say it's only in the Caribbean that it's happening. From the case, and I would encourage members of the public to read the case before considering the headlines that are out there. Sit and read the case, because it's very easy to understand, and it explains clearly why that particular decision was taken, that certain sections of our act has to be amended in the sense of to allow consenting adults to engage in the act of burglary, and also to allow consenting adults in the privacy of their homes to engage both in burglary and in gross indecency. So, in closing, I would say, read the case. You'll understand why the court, clearly why the court gave that particular decision, and you will understand why the first thing that was said by the minister today is that burglary has not been decriminalized. Okay? It is, we allowed in certain circumstances, certain concessions have been made to engage in the act. But it's not a matter where everything has been thrown out from the books. It's no longer on the books, burglary is no longer on the books, and that's it. No. It is still remains an offense. Burglary still remains an offense in the Sexual Offences Act, Chapter 1036, where the maximum penalty can be 25 years. Gross indecency still remains on the books. And in keeping with these two sections, I would say that there are other sections that also assist in understanding our social context. We also have the sections of grooming, which was not there prior to 1998, when you encourage children to partake in certain sexual activities, minors that is, to engage in certain sexual activities. Someone, an adult, can be prosecuted for that. So I think too that was a concern of the public, that can individuals who engage in burglary, acts of burglary, force that onto minors? No, it cannot be done. They can be prosecuted if it is done at all. As of under the Sexual Offences Act, we have gross indecency, we have defilement, we have rape, steal. So there are very serious offenses under the Act with strict, very high custodial sentences attached to them. So there has been no breakdown of the law in respect of the sexual offenses of burglary and gross indecency. Just minor concessions which were given by the court.
Thank you, Ms. Dianko, for this presentation on sections 14 and 16 of the Sexual Offences Act, Chapter 1036. We would now like to open for questions from the press.
but my first question is, do you guys intend to have town halls or town councils to explain to the locals what is going on? Although we have had this press conference today, it's impossible for everybody to view it and understand what the law says. So do you intend to do that? The next question is that a lot of people are worried that this amendment will lead to same-sex marriage, so can you address that? As well as, did the court or the ministry meet with the Christian Council before amending the Constitution?
Thank you very much for your question.
I will start with the last question. I do not propose to answer all the questions, but I can start with your last question. To clarify, the Constitution has not been amended. The law, the Sexual Offences Act, sections 14 and 16, have been qualified or modified to be read in such a manner that the blanket criminalization of every act is no longer the case. The only thing that is allowed, consenting adults, male, male, female, female, male, female, in private. But the Constitution is not what has been amended. The section in the Sexual Offences Act is what has been amended. I do not recall what the second question is.
Same-sex marriage.
As I indicated earlier, whether or not same-sex marriages will be legalized is a question for the policymakers. It has been reiterated that we are still a God-fearing society, and predominantly we know what the Bible says. As it relates to whether it will be, that is not within my purview, but what I could emphasize is this case does not legalize same-sex marriages. The ruling in this case does not legalize same-sex marriage. It also does not legalize buggery. It also does not legalize gross indecency. What it has done is it has said that two consenting adults in the privacy of their home can engage in the act and they will not be criminally prosecuted. As it relates to the town hall question, I will defer to the Honourable Minister on that.
Okay. I want to commend you again, Mr. Sobers, for speaking like a real politician. Just to say on the issue of town hall meetings, as you know, that's a second attempt by the ministry to edify the public on the actual ruling itself. Days after the ruling, we had a program, almost 2 hours, on the national station, expressing the real facts. And that is why we're here today, to continue that effort. And I feel there's merit in what you've said on the town hall engagement. And that is why I think that each one of us here have the responsibility to engage the public and then to disseminate the information via various platforms, social platforms, and also radio to the public, and within the schools and churches, etc. So that's a good. Insofar as same-sex marriage is concerned, and I'm happy that reference was made to the issue of discrimination insofar as sex is concerned. And our Constitution is written in a way and guided by the principle of Christian principles. And gender within our confines of our laws, of our society, a man and a woman. Right? And marriage, a man and a woman. And so that ruling has nothing to do with same-sex marriage. What I can say to you, what the government has done was to have gone to Parliament and passed the most sweeping amendments in the Sexual Offences Act. This is the court. It is the court, based on a challenge that qualify certain elements within sections 14 and 16 as it refers to two consenting adults. And these are the operative terms, eh? Two consenting adults within the confines of privacy. Let us suppose hypothetical. If Tom was an adult, invite Gary, I don't call anybody, okay. John Brown was an adult at his home to eat a braff. And during eating the braff, if you give the other guy some rum, guy charge, and you decide you're going to him. That is not permissible by law. This is burglary if that were to happen. Even if they're two adults. One didn't consent, one was induced, one was, whatever the case may be, one was forced. Do you understand what I'm saying? Even if it happens within the confines of privacy, the adult has to consent. So that has nothing to do with same-sex marriage, and insofar as domestic laws are concerned in terms of making provision for that, what we have done as a responsible government, mindful of our Christian values, is to pass laws to prohibit, the engagement of those kind of sexual or natural activities. Whether you were to consenting adults within the privacy of the home. That's how far we are gone. Okay? So, you prefer same-sex marriage. Right? Nothing. And that would be a difficult one to expect. Any change to our laws to give effect to same-sex marriage. As I've said, I mean reiterate, this is not a lifestyle that I subscribe to, and I've never subscribed to. But we have to be adult enough to appreciate we live in a democratic space. And if you have an appreciation for the separation of powers, and the court has ruled, a challenge has been brought, we have to accept it and do not go out violating or seeking to black eye anybody. I want to just say further. We always point fingers at the politicians. Rightly so. We take our blows, that's cool. But we set aside our individual and collective responsibility in society. Look at this. We went to Parliament 2016 and overhauled our Sexual Offences Act for the express purpose of protecting the most vulnerable in our mix, especially minors, children. And the law that we have passed places an obligation on parents, teachers, guardians, doctors, nurses to report any such suspicion or act of sexual violation on a minor. And then you can be held liable, criminally liable under the law if you're a teacher, if you're a parent, a guardian, or somebody who has been entrusted with the care of a minor and not reporting that to the police. That's how far we have gone, to Parliament. And then it will turn back and blame the politician for not reporting incidences where you have an obligation by law so to do. The last thing I want to make reference to, alright, because some people are very good in getting upset and they go on social media and say all kind of different things about the Prime Minister, about ministers, instead of trying to get himself educated. And and hate never solve any problem. So even if you go and have multiple press conferences, because some people have their own methodology and reality, they're going to believe what they want. My last one I want to make before you go to the next question, and I am very much concerned about that, is the issue of incest. Whereas we speak a lot about two adults within the privacy of the homes, doing something that most of us don't agree with. And a lot of us don't agree with the court ruling. Do you understand what I'm saying? A lot of us but we have to be adult enough to understand how the legal system works. But we have under Section 6.1 of the Sexual Offences Act, the issue of incest, which is to me one of the most animalistic and diabolical acts that can be committed within any society. And the law goes as far as to demarcate when certain offense is committed. Father, parent and child, brother and sister, uncle and niece, grandparent and grandchild. That's what the law says. But it has been condoned, and they blame the politician. You understand what I'm saying? The law is there, and it's placing an obligation for people to report those things. These are all the things that this government has done, you know. So, we have to be mindful that while we're pointing our fingers at people, the form is back in our faces. And this element of hypocrisy that we have to address frontally. This Sexual Offences Act is comprehensive in scope and demonstrates the intention of Parliament, the intention of the Executive Cabinet, who went to Parliament and to pass those sweeping pieces of legislation to protect the vulnerable economics, the minors and non-consenting adults. And there's a next segment of people I want to talk about who's also protected. I'd like to term, even one of the police officer, MBC. We call them the dumb, right? Deaf and dumb people, etc. They cannot give consent. Even if they were to say yes, they cannot give consent, and you would do that to them, even if they're adults, that's an offense. Do you understand what I'm saying? All that we have covered, you know. So it's important for us to understand this thing, and I believe that is why we have started the program within the ministry the second Thursdays and last Thursdays of the month. I think we should engage on our media platforms to educate the public on these fundamental issues of law, and they can know their rights and their responsibilities. And this Sexual Offences Act places a legal responsibility to report on many people, not the politicians, not the Prime Minister. We have a responsibility, brothers and sisters, collectively, to address those things that happen in society. It's one thing to go on social media and just, we have got nothing to do. We have not read anything and just posting all kind of hate and stuff like that. But another thing to be a Dominican, to be an adult, with a conscience. You do get my point. A conscience. And no one with a conscience can engage in sex with his daughter, his grandchild, his niece, his granddaughter. So it's not only that. We have to look at the Sexual Offences Act in its global sum. And those laws are in the books. Unless if some of us want, only the Minister of National Security and the General Prime Minister to come and knock on people's home. Don't do it now. You have anybody you commit any act against the minor or force anybody inside there? You have a responsibility because it's not the home. That's how society works. And I can tell you, I know how it feels. Look, Mr. Valera was there. He's Commissioner of Police. He used to call me Sergeant before. We would say it together. Before we had the abundance of female police investigators, a number of us did sexual offenses, including myself. I can tell you the impact it has on a minor. That child is never the same again. And it's been condoned, you understand, by homes, by adults. Those are the things we have to address. And notwithstanding everything I've been said about me, I have no regard and respect for any man who interferes with a minor or raises his hand on a woman. I swear. Absolutely no regard. That is what we have put on the books. We overhaul. I want to really call out and shout out my partner, Mr. Riaris, a great Dominican. Sat down and had consultation with relevant groups and overhauled the sexual offences act to the extent to which people told us we were violating people's rights under the Constitution. And for the extent to which, when I went to Parliament, I don't call it, but some pastors and priests who messaging me and telling me we're going to allow women to take the foot on men. Because once a woman married to a man, she cannot say no. Can you imagine that? And that's why I started saying to myself, I'm going to start going to church less. Okay, man? I'm going to start going to church less. Because if a man has it in his psyche, and a woman cannot say no, you understand? Because they're married. You see what I'm saying? We have a fundamental problem as to how you see a woman. You get my point. But the point figures and folks like myself, because we really walk, you understand? But I have absolutely no regard. You see what I'm saying? For any man would believe that a woman is inadequate to him. No regard. Because we have been there, investigating those matters. And today I'm happy to be part of the government who is taking a very strong and serious stand on that. That notwithstanding, those who are doing nothing want to point their hands and fingers at the Prime Minister and the administration. This is not right at all. You have a right to criticize us for policy matters, it's a right. But don't let everything just bless us just like that. For no reason. Okay, I think I've spoken enough, so let's continue question.
Question, so it's good to hear.
Thank you.
It has been suggested out there that some of the changes that we now see is as a result of external pressures. We saw the Samoa agreement just being signed in Brussels. Can you speak to that?
Well, obviously, I mean, there's merit to an extent to what you're saying. There are also pressures, and the agreement, insofar as having an impact on the domestic legislation, is almost inconsequential. You get my point. There's no inclination, from what I know, and as the Minister of Legal Affairs and knowing the Prime Minister, where we're going to amend our domestic laws to give effect to same-sex marriage and other issues, to be quite honest with you. And we define gender as a man and woman. And we have a responsibility, as I made reference to the foreword of our Constitution, it's founded on the principles that acknowledge the supremacy of God. You see? And that is how our laws have been crafted going forward. So we also appreciate that the world is changing, and there are certain things that we have to adjust to, but it's a different mindset when it comes to going to Parliament and adjusting our laws to give effect in a value system that we do not subscribe to.
Will it come down to a point? Will it come down to a point where we will see in the laws where a gay couple might be able to adopt a child?
Well, at the same time, that's a hypothetical question that I want to answer at this point. My focus right now is the reality now that we're speaking about. Let me just say something to you. I mean, we have learned a lot. I went to school in Canada, both university and college. And this is a country where you have the issue of sexual orientation. And I had absolutely no problem with anybody. Everybody knew where I stood. You get my point? I'm not the kind of person who's going to actually, folks with that kind of lifestyle, we did group projects together. They knew they had to hold my hand, and I hold my hand. You get my point? So, but I don't want to get myself involved in black-eyeing somebody because the person chooses to do what he or she wants to do as an adult. Do you understand what I'm saying? I don't want to get myself involved in that. When the young lady was brought before Christ and for committing adultery, and then in those days, the punishment was that the woman would have to have been stoned to death. And he asked them a very simple question. He who has not sinned cast the first stone. You know what they did? They looked at him and they turned their back. Because they know all of them had sinned. So, the reason why I'm saying that, even if we do not subscribe to a lifestyle, I don't subscribe to it. We have to be careful You understand? That we do not sweep certain things under the rug. Incest. You understand? The people reluctance to report the sexual abuse of minors under the care. Do you understand what I'm saying that? And then we just focus on one issue. But we have to look at the global sum in totality. I can recall doing a matter. And then the father was the stepfather of the child. Next thing, not far from where the financial center is. Next thing, a couple months after, the mother was vexed with me. Because she put the welfare of the man over the life of that young child. Was about 8 years old. You get my point? I'm not saying, folks, listen to me well, that we are involved in theater to an extent when we are acting, and we're not addressing some of the things that we ourselves need to address. For us to actually ensure that the Sexual Offences Act in totality is properly effective and is effective, we have to play our part by reporting people who are under our care, who have been violated by our boyfriends, by our husband, or anybody. Incest. You see, understand that? Not having an understanding of our human biology and the impact it can have on society. We have a number of children having Down syndrome. You get what I'm saying? When you have father and daughter involved in sexual intercourse and giving rise to children, it has an impact on society, and it impacts on the health system, the healthcare system. We have to understand those things. So I am happy having a discussion, and the whole idea of having town meetings with the technicians going out and explaining that around the country, I think it's something that is very, very, very noteworthy and needs to be explored. Any other question before? From here? Hello? Any other question? Normally I give credit to JS, isn't that so? Yes. So, because if I were to say about green pathway, is a word I don't want to really say. You understand? So, I'm not figuring out where to say it. So I prefer to. Yeah. So I'll do it. Yeah. Thank you very much, folks. I think you guys were very professional. Have a nice day, and we'll continue the engagement. And that's our second time we're doing that, and we'll continue engagement. Yeah. Before you go, let's.